Hello and welcome to our listening session. We are going to get started here probably about 3:02, just to allow time for folks to get into the room and get settled. So for those of you who are joining us, thanks for being here and participating in our listening session. Again, we're going to get started right at about 3:02. We'll be monitoring attendees and see when our numbers start to balance out here. And for those of you who are just joining us, we're going to get started here in just a minute. We're just letting folks come into the room and get settled and make sure everybody is here before we get started. So we'll be ready in just a second. All right. Thank you all for being here. We're going to get started. It looks like our numbers are pretty consistent and we have a lot of material to get through today. So once again, thank you for being here and welcome to our listening session. I'm Ariel Finney, the WACARES Fund Policy and Rules Manager. I'm here with Christine Kane, our WACARES Fund Provider Network Development Program Manager. We're part of the Department of Social and Health Services, Washington Cares Fund, and we're working on rulemaking for a new chapter of Washington Administrative Code. We will be addressing rulemaking for the Department of Social and Health Services. Please know that the Employment Security Department is also doing rulemaking for WACARES Fund program, so please reach out to Employment Security Department if you're interested in their rulemaking activities. In Chapter 50B04 RCW, qualified family members can be paid as individual providers through a home care agency or through a third option. We're here today to discuss the third option, which we're calling eligible relative care. We will ask for public input on some questions that we will be posing here later in the day or later in this presentation, and talking about kind of some different options and continuing our discussion that we started in December. This is the second listening session regarding eligible relative care. If you missed the first one, please note that the recording is available on our website, and I will share that with you here throughout the presentation. But you're welcome to go back and listen to that and provide comments on that through email to us as well. We're hoping to learn from each of you today, and really we're here to just have a discussion and hear your feedback on the questions we have posed for our listening session. This listening session is in relation to two CR 101s, which were filed in January of 2024 with the Code Revisor's Office. The topic we are discussing today is a subcategory of approved services and provider registration and minimum qualifications. For those who are new to the rulemaking process, a CR 101 provides notice to the public of intended rulemaking. A CR 102 is when the department files draft language for public comment before finalizing the language through a CR 103. We're still at that CR 101 step. I mean, we filed the 101, but we are working towards our draft language for CR 102. And the listening session we're doing here today helps inform how we draft that language for our 102. This listening session is specifically for eligible relative care. We are recording today's session and we'll make it available on the WACARES website. Please share this information with those who you think may be interested. And again, I'll have information here at the end. All right. We're going to cover our agenda here briefly. For those of you who've joined us before, this is going to be a very similar format to ones we've had in the past. We're going to start with some housekeeping and common terms. And then I'll pass it to Christine Kane to provide some information regarding it with a brief refresher over the information we covered in our first session, as well as discuss some options. Hearing a lot of great feedback from our first session, we want to dig in a little bit deeper today and talk about some different pathways. This session is scheduled for an hour and a half. We may end early if the discussion is complete, but I know from our first session we had plenty of things to discuss, so I do expect we'll go that full hour and a half. If we need more time or we do not cover all the material today, we'll do our best to conduct another session or to connect with folks who may need some more time to discuss the subject with us or generate some ideas. But I'm fairly confident we'll be able to work through our material today and have an understanding of where we want to go. Some housekeeping before we begin. The question and answer feature is available for questions throughout the presentation today. We will do our best to address those questions as we go, but please be patient if your question is not answered live. We may need to follow up with you outside of the session if we're unable to incorporate the question during the session today. The chat feature will be disabled during the presentation, but it will become open when we begin our discussion prompts. The recording of this webinar and the slide deck will be available on the website on the screen here. That's our WildCares website. And we also have the recording for the previous listening session for eligible relative care at that same link. I will share this link in the chat at the end of the presentation, but please allow us a few days to process the recording and post it to the website. Some common terms here that we want to cover that may be used throughout our presentation today, as well as through our discussion. I will do my best to explain these terms or ask for an explanation of terms as we use them, but it's always good to start from a foundation of understanding here. So to start off with, we have the Department of Social and Health Services, who is the lead on the WildCares Fund project. This listening session is focused on the work being done by the Department of Social and Health Services. You will commonly hear the Department of Social and Health Services referred to as DSHS. Employment Security Department also has a major role in this project. Employment Security Department is leading the work on employee contributions. You will commonly hear the Employment Security Department referred to as ESD. Healthcare Authority is the third department responsible for a major part of the WildCares Fund program. They are responsible for the payment system, verifying use of benefits, and establishing criteria for payment of benefits to providers. You will commonly hear the Healthcare Authority referred to as HCA. Long-term services and supports, or LTSS, refers to a variety of services and resources to assist people who experience a long-term disability to maintain their safety and comfort. The Revised Code of Washington, or RCW, refers to our statutory language, which is the language enacted by the legislature. These are the laws that provide program direction, limitations, and grant permission to state agencies for rulemaking. You've already heard me use the term Washington Cares Fund, or most commonly WACARES Fund. You may see WACARES Fund referenced as WCF. And Washington Administrative Code, or WAC, are rules developed by government agencies to implement policies and procedures as delegated by the legislature. You may also hear WACs referred to as rules or regulations. Some terms we're specifically going to be using today are going to be Consumer Directed Employer, or CDE, which is the legal employer of individual providers in the state. The consumer is the managed employer of individual providers and retains the primary right to select, dismiss, assign hours, and supervise the work of one or more individual providers. The state's contracted CDE is Consumer Direct Care Network of Washington, or CDWA. An eligible beneficiary is an individual who has met the contribution determination and has been determined functionally eligible based on eligible care needs assessment. Eligible relative care means assistance with activities of daily living and instrumental activities of daily living provided in the care recipient's home by a qualified family member who meets long-term care worker requirements. This is what is commonly referred to as the third option. Long-term care workers, or LTCW, are people who provide paid hands-on personal care services. Personal care means physical or verbal assistance with activities of daily living and instrumental activities of daily living provided because of a person's functional disability. I'm going to take a quick break here as I recognize that I may have an incomplete slide here and I want to make sure we have the right information. So give me just one while I pull this down and double check that we have the complete information here. So thank you. All right. This looks like we have all the terms that we need here today. So thank you for your patience as I fix that. All right, let's continue on here. We have personal care, which means physical or verbal assistance with activities of daily living and instrumental activities of daily living provided because of a person's functional disability. Agency with choice means that an employment model where participants choose and manage their caregivers with administrative support by the agency. And FEA, or fiscal employer agent, is a model where the participant is the employer and the agency manages payroll and tax liability. So with that, thank you once again for your patience. I'm going to be turning this over to Christine Kane to cover a brief refresher and our options.
Great, thank you, Ariel. So as she mentioned, I'm going to start with providing a brief refresher of what we reviewed in our first listening session and going over some of the things that we heard. Next slide, please.
And I will move on, but Christine, even though we tested this beforehand, we are getting some challenges with your audio. So we'll give it a little bit here, and if not, we will take another pause here and troubleshoot that.
Okay. Thanks for letting me know. Yeah, last time I had some issues. I was doing my best to try to prevent it. Okay, so I'll start with a reminder of the statute here that opened the door for WA Cares to have a third personal care option. RCW 50B 04070 states that qualified family members may be paid for approved personal care services in the same way as individual providers through a licensed home care agency or through a third option if recommended by the Commission and adopted by the Department of Social and Health Services.
And Christine, I'm going to pause this once more here, and I apologize for interrupting. If you turn your camera off, and then let's start this slide over again and see if that solves our audio problems.
Great, thank you. My apologies, everyone. Okay. So I'm going to just kind of reintroduce again the statute that opened the door for us to have for WA Cares to have a third personal care option. RCW 50B 04070 states qualified family members may be paid for approved personal care services in the same way as individual providers through a licensed home care agency or through a third option if recommended by the Commission and adopted by the Department of Social and Health Services. So in July of 2024, the LTSS Commission's Minimum Provider Qualifications Work Group recommended to the full Commission that the development of the third option be deferred to DSHS rulemaking, and that motion passed. So again, once DSHS had confirmation from the Commission that a third option was to be developed, it was decided to title the new service Eligible Relative Care. eligible relative care is an approved service listed in the WACARE statute, that had not yet been defined. I do want to add a quick reminder to the definition of a qualified family member. So that is any relative of the beneficiary, including a spouse or domestic partner. Next slide, please. Last session, I covered quite a few things that needed to be considered in the development of this service, and I wanted to just highlight some of those from the last session for our purposes here today. So again, eligible beneficiaries can pay qualified family members through a home care agency, through CDWA, or through eligible relative care. Qualified family members will have the same background check and training requirements regardless of which option is chosen. So provided legislation is passed to align existing family member training and certification requirements. WACARES will have a self-directed care agreement for beneficiaries and their family caregivers. DSHS will not directly register or contract with eligible relative caregivers. And WACARES will not have case managers. We heard a bit in the last session that there might have been some concern about the wage of the family caregiver and kind of how do we protect that or plan to address that concern. So just at a high level, I added in this last dot point that consistent with the commission's recommendation, WACARES intends to keep the wage the family caregiver earns through eligible relative care comparable to that of individual providers and home care agency caregivers with with a wage pass-through requirement. So again, we're not going into rate or wage here, but we did want to alleviate any concern that might have been conjured up from the last meeting session with questions around that. Next slide, please. So again, just another reminder from the previous session that will help us going forward today. So some requirements that the department has for the development of this service is that a contracted third-party entity must ensure that all employment taxes are paid appropriately. They must be the liable party for any unpaid taxes, ensure compliance with wage and hour laws, ensure adherence to statutory training and background check requirements for the caregivers. Next slide, please. So here I'll go over the themes that we heard from the first listening session and that we've taken into consideration for the second session. So the themes we heard were that it was important that we are informing the beneficiary and the family caregiver of their options, making sure the family caregiver has proper training, honoring a beneficiary's autonomy, choice, and dignity of risk, minimizing external involvement in the beneficiary caregiver, family caregiver relationship, having worker protections in place, having the right to unionize, maximizing the limited benefit amount, and protecting beneficiaries from exploitation, fraud, or harm. So again, those are just some overarching themes that we picked up on from the first listening session that we wanted to share back with you all. Next slide, please. All right. So with that, we'll move into reviewing two models that we want to present and get feedback on today. Next slide. So in balancing the department's needs with the feedback and suggestions from our first listening session, there are two models that we're interested in pursuing, and they are both operated by a financial management services company. So we want to kind of give an introduction to an FMS for those who are not familiar. So the general kind of definition of an FMS provider is that they act as a fiscal intermediary for participants in self-directed programs. The basic duties of an FMS are to track and manage the budget, pay care providers, and or pay for approved services and supports. So these services are provided through three models that the FMS vendors offer. One being a fiscal agent or fiscal conduit, the fiscal employer agent, and the co-employer or agency with choice models. Um, some some examples of FMS vendors being used with DSHS now are the New Freedom Program, where we have a company, Access Washington, who acts as the fiscal conduit for that program's participants purchasing goods or services. And then we have CDWA, who operates like an agent, is an agency with choice. The two FMS models that we're going to focus on for eligible relative care, which are the two models that pay care providers through an FMS, are the fiscal employer agent and the agency with choice. Next slide, please. All right. So I'm going to kind of go over some things about both of these models that they both offer. So again, they're both offered through an FMS vendor. They would both meet the department's requirements in managing the service. So again, the covering taxes, adhering to employment laws, the training compliance, those things. Both will require enrolling with with the FMS, which both will require, I guess, the beneficiary enrolling with the FMS vendor, sorry, which will include paperwork, account setup, getting the family member hired, doing pre-authorizations. Both models are customizable. So for example, we could build into our program requirements with the vendor, to have help with paperwork, help with hiring or firing, providing monitor calls. We could set it up that they have to confirm the care agreements. So there are some options available to make it program specific. Next slide, please. All right, and then just a few more things here, continued. The day-to-day with both models will look very similar, where the beneficiary is making those supervisory decisions. They will both process timesheets and ensure timely payroll for the family caregiver. And they'll both ensure the family caregivers are adhering to the beneficiary's pre-authorization as it relates to their rate and number of authorized hours. So again, that was an overview of kind of what both models will offer. And now we'll kind of move into looking at each one separately and where they might diverge a bit. Next slide, please. All right, so we'll first take a look at agency with choice. So this is a joint or co-employer model. The agency with choice is the employer of record for the family caregiver, but the beneficiary manages the caregiver's tasks and schedule. Family caregivers could unionize due to the agency being the employer of record. The beneficiary would not need to complete a lot of paperwork like they would in the FEA model, which we'll get to, but likely with this model, they would just need to complete the I-9 for hiring that family member and some enrollment forms with the agency. And on average, this model has a higher service fee or rate than an FEA model, as the agency here does take on full employer-related activities and liabilities. Next slide, please. Thank you. All right, so now we'll take a look at the fiscal employer agent model or FEA model. So here the beneficiary or their legal representative is the employer of record, and the FEA would hold tax liability in this model. To become the employer of record, the beneficiary would apply for a federal employer identification number or an FEIN. The beneficiary would be required to complete any associated or required IRS forms, so that to provide to the FEA to file, again, as that legal employer. This model is more hands-off in the employer-employee relationship. So once the beneficiary is enrolled and the caregiver is hired. For example, a fiscal employer agent does not help find or hire caregivers. They aren't offering benefits to caregivers that aren't required by law. They wouldn't be involved in investigating complaints or disciplining caregivers, again, because the beneficiary is that legal employer. The FEA would not be responsible for those things. So a bit more removed. And because the beneficiary is the employer and the FEA would not provide as many services to the beneficiary or carry as much liability or responsibility to the caregiver, it is less costly than the agency with choice model. Next slide, please. Right. So now we'll take a look at a comparison chart so that you may get a better picture, hopefully get a better picture of the two models and where they're similar and where they're different. You'll also see that we've got columns there for CDWA and home care agencies. And that's just to kind of provide reference of like how these two options might differ, kind of, you know, and what's happening now with our two existing personal care options. And one thing I want to note is through this slide and the next where we're comparing, you'll see program requirements. And when I mention those, what that means is that it's something that we can build into the contract with the FMS vendor as being required. So it may not be like a service they offer offhand, but we could build it in again to our program requirements with them. And to go that way. Okay, so I'm just going to jump in and start going through these topics and we'll take a look at how each of the models compare. So the first one is the beneficiary, the legal employer. So again, with the agency with choice, no, the beneficiary is not the legal employer. And yes, they are with the fiscal employer agent model. Is this a joint employment model? So with the agency with choice, yes, it is. With the FEA, nope, only the beneficiary is the employer. Do current training requirements apply? And that's a yes with both. Do background checks apply? Again, yes, across the board. Are health benefits required to be offered? So with an agency with choice, they would be required to offer health benefits to family caregivers if they employed 50 or more full-time employees. That's the threshold set by the Affordable Care Act. No, they would not be required to offer it if less than that. They didn't meet that threshold. And with the fiscal employer agent, no, they're not required to offer benefits, health benefits. Next, is there paid time off or sick leave available to the family caregivers under the agency with choice? Yes. What is required by law? Or we could look to add on to that under program requirements potentially. And with the fiscal employer agent, yes, it can be part of the program requirements to offer this, but they would not be required there wouldn't be anything they'd be required to offer by law since they are not the employer. The last one on this screen, so the labor and industry taxes withheld, so the worker compensation. Under agency with choice, yes, those taxes would be required to be withheld. Under the FEA, it's optional for folks, for the beneficiary if they're only employing one person, or we can set it up as part of the program requirements that those taxes are withheld. So again, I think I kind of fumbled over that, but it's optional if an employer is only employing one person, or again, we can set it up as part of the program rules. Next slide, please. All right, and so just to finish out this comparison, would other required taxes be withheld, such as like paid family medical leave, the walk cares, et cetera? So with an agency with choice and with the fiscal employer agent, yes. So again, they're responsible for withholding all applicable and appropriate taxes from the family caregiver. Who is responsible for unpaid taxes? So each agency here would be responsible. So the agency with choice and the FEA would be the responsible party. Ability to unionize, that's a yes under agency with choice, and it's a no under fiscal employer agent. Does the caregiver qualify for overtime? Yes, in both cases. So overtime laws would be applicable and they'd be monitored by the agency with choice and the FEA. And lastly, who resolves concerns with quality of care? So with agency with choice, because they're in that co-employment or joint employer model, it's the agency in coordination with the beneficiary that would be responsible for resolving any concerns around the caregiving. Under the FEA model, it would just be the beneficiary. Again, they're the sole employer, fully responsible for that employer-employee relationship and the quality of work that's being done. So that concludes our overview and comparison of the two options that we are considering for eligible relative care. So at this time, I will go ahead and turn it back over to Ariel, who will move us through our discussion. Thank you.
All right. Well, thank you so much, Christine. I think that was a good foundation. I have turned on the chat feature as we begin our discussion here. And also, I will be working on making sure everybody is able to raise their hands as participants here. But for those joining us for the first time, we're going to be following this discussion format that we've used in the past. We will have several discussion prompts we'll be asking for your participation and engagement with. We ask that your feedback remain focused on the prompts we're discussing to make sure we receive detailed feedback on the areas we're hoping to understand more. To participate in the discussion, please use the chat feature or raise your hand to ask to be unmuted. I will unmute you based on the order hands are raised. You will be limited to about 2 minutes for sharing to ensure there's time for everyone to be heard. All right, and we are going to jump right into our first question here. To kick us off with discussion, what are the minimal supports needed for the beneficiary? So when we think about eligible relative care and all of these options, our first question is really just like, what are the minimal supports needed for the beneficiary when it comes to eligible relative care? So while we're working on that, I am going to do a few things here. So I will give us just a few seconds to pause and think about this, but please feel free to jump in the chat and engage in that way. And you should be able to raise your hand and I will open up the permission to have you come off mute. I have dropped a document here in the chat that for folks who want to see that comparison chart that we just showed on the slides as we talk about these different discussions, then you'll be able to follow along with that. And I understand that I missed the opening of the chat there, so you should be able to participate in the chat now. Thank you for letting me know that, Caitlin. So you should be able to now engage in the chat as you would like. But again, we have a document in there. If you want to use that as kind of supporting the discussion as we go, you're welcome to. And that's, again, the same visual that we just showed over the last 2 slides here of the presentation.
Hey Ariel, this is
Mhm.
B. And I was just wondering, that was a lot of information. And I know we've had lots of time to digest it in the department because we've been working on kind of the comparison of the two models. Just wondering if it would be beneficial to see if anyone has questions on the models at all. They may not. It was a lot of information, and you've got the resource document in the chat. But in
Yeah.
addition to maybe responding to this discussion item, if there are like burning questions, just to understand the two models that got discussed that fall under the FMS umbrella, we welcome that too, because I think it's important that people kind of understand the starting place here.
Okay. Yeah, we can certainly pause our discussion to make sure there's room for folks who have questions about the models we presented. Does anybody have any questions that they would like to clarify? Okay, I see Katie, I see your hand is raised. You should be able to come off mute now.
Hi, Ariel. Thank you. I am just looking down the chart and really looking at the near identical similarities between agency with choice third option and what CDWA is currently structured and offering. And I heard noted in one of the earlier slides, I think that CDWA is working as agency with choice for the additional program. I'm blanking on what the name is right now that you had mentioned. But is there really a difference between what CDWA is offering now as an employer versus what is here on the agency with choice third option? I guess I'm not understanding what the benefit would be with creating the third path under agency with choice.
Yeah, B, go ahead.
I think it's a great question. We in the contract terms of CDY, we really defined what we knew we needed for the Medicaid space. So it could be that some of the requirements could look a little different in a second agency with choice that exclusively served WACARES. That's one possibility. I know that we still have not done rate setting for the third option for any of the provider types. So potentially the rate might be different in CDWA and or another agency with choice. And then for folks working in the Medicaid space, they know that there are a lot of struggles right now in terms of timeliness of hire in CDWA. So, I have been really honest and open with folks that I have been working with that I think if we have an agency with choice model in WACARES, we need to have probably more than one choice of that in order, that we can just make sure that there's a really speedy access point and options around that.
So B, just to clarify what you said at the very end there, like potentially if it was an agency with choice model, you could have more than one vendor serving under that contract.
Right. Um, And it may be that a third option is more than one of these types of providers too. I think that's part of what we're, working on as we get through this rule writing. But yes, I mean, you probably know, Katie, that our intent was to have at least two in the consumer directed employer space, but that did not work out through the procurement and contract negotiation.
I do recall that. Okay,
Yeah.
that makes sense. B, why that would differentiate that from what's currently offered. Got it.
All right. Thank you for that. Does anybody else have any discussions or any questions about what we've discussed so far about agency with choice or the fiscal employer model? And I do see that there may be some challenges with opening the document in the chat. And if that is happening for folks, I'm happy to follow up in an email here once we're done. So you're able to access that and see the comparison. All right. I'm not seeing any other questions come in the chat. Looks like Lindsay was able to open the document, which is great news. Oh, Michael, I see your hands up. You should be able to come off mute now.
Good afternoon. Can you hear me?
Yes, I can hear you.
My name is Michael Howard. I'm the Executive Director of First Choice In-Home Care, and I've been asked to express some of the concerns that the Home Care Coalition has with the Fiscal Employer Agent Option, FEA for short, we'll call it. If you'll indulge me, the primary concerns are the approach has been effectively tried before, and the outcome of that approach many years ago was costly litigation due to the lack of regulatory oversight. There's concern that we have that this option will lead to increased infrastructure costs and new pressures on the Medicaid home care system to backfill those costs. And mainly the concern is the proposed option lacks the hard-fought consumer and employee protection mechanisms that are provided in the current two-tier system with CDY and agency employers, introducing needless risk to the state's oversight capabilities. The reason that the gestation of these concerns is that we've effectively in Washington done this approach before many decades ago. And the pursuant to that experience, there was a 1981 DSH a report on that, a similar approach to this where the client acted as the employer. And it was determined in that report by DSH that that was an unsuccessful model for the state due to elderly and disabled consumers struggling to act as employers. It was brought up already, quality assurance being a concern, and that the consumer would be responsible for determining that quality assurance. The other aspect that was raised in that report was challenges for DSHS to monitor this system effectively. And there were some high-profile lawsuits that resulted from neglect and spousal abuse that underscored the dangers of lax oversight. I can tell you, as a former litigator myself, attorneys love nothing more than lax regulation. In 1999, the legislature reviewed the program and identified accountability and quality assurance weaknesses throughout. Reforms were brought forward through Initiative 775 in 2001. Subsequent legislative actions have since addressed those flaws. So from the coalition's perspective, we're concerned about reverting back to what was deemed a flawed system by DSHS previously, how that's to our benefit. There's also kind of an underlying concern, which is we talked about benefits briefly and the comparison points. CDY and agency providers contribute currently to the SEIU Health Benefits Trust, resulting in tens of thousands of caregivers receiving excellent health care.
Michael, I'm going to ask that you start wrapping up the comment here. We're at 2 minutes.
Okay. Well, the adverse selection issue would be that healthier individuals who don't feel they need insurance would opt out, leaving CDY and agency providers with higher healthcare costs. Ultimately, that would have to be backfilled by the Medicaid funding through the vendor rate. Potentially right-wing austerity measures to alleviate federal and state budget deficits are coming online. So we are requesting that the FEA option not be pursued because of the risk to consumer safety, oversight, and fiscal responsibility, outweighing any potential benefits of a lower cost system as it's been claimed. As the adage goes, you get what you pay for. We do have serious concerns about this proposal.
Thank you, Michael. Thanks for sharing. All right. I am going to keep us moving here as we do have discussion questions that are ready to go. I don't see any more questions about the FEA or agency with choice options, and just clarifying that to be able to move on to our discussion. So I am going to bring us back to our first discussion point, which we saw briefly here just a second ago. But what are the minimal supports needed for the beneficiary? And this is where we look to you all as experts in the room here to share with us in the chat or raise your hand and come off of mute your thoughts about what are the minimal supports needed for the beneficiary. See, Brian said for the vast majority of beneficiaries, the key minimal support needed is handling the fiscal responsibilities like payroll, taxes, and so on. Wonderful. Thanks, Ryan, for kicking us off here. What else do we have regarding the minimal supports needed for the beneficiary? And for those of you who may be joining us for the first time in a listening session, this really is just us having an opportunity to hear your thoughts on some of these questions. So we've gone through kind of the presentation part of the session, and now we really look to you all to let us know from your experience, your background, your field of expertise here. What should we be thinking about as we think about eligible relative care, supporting beneficiaries, supporting the provider, and navigating this new service? So our question for you all is, what are the minimal supports needed for the beneficiary? And we do have quite a few people in the room here today, so I'm excited to hear some thoughts. So Lynn added in the chat, I appreciate that the FEA option gives beneficiaries the opportunity to directly employ and manage their family members. The minimal supports needed would be some basic direction on where to go to complete FEIN. And Lynn, if you could add in what FEIN stands for, that'd be helpful. And how to register with the FEA, which is the Fiscal Employer Agent. Like discussed in the last session, having good resources for beneficiaries to make informed choices between the options will be extremely important. As for risks, the technology and supports available to assist consumers in using an FEI model has significantly advanced since the 1980s. Maddie adds, regarding minimal supports, I think beneficiaries should have support revolving concerns with quality of care. Also specifically for beneficiaries with cognitive impairments, may need even more supports to access and supervise their care. And Lindsay added, timely hiring, processing, training of caregiver. And then also Lynn's following up on a question I asked regarding FEIN, that stands for a Federal Employer Identification Number. And it was presented earlier, but thanks for clarifying, Lynn. It's always helpful to keep track of that for folks who may be seeing this for the first time today. So thanks for helping us out there in the chat. I appreciate it. All right, so what else? I know, again, we have a lot of folks here in the room. I see hand raised, so Muriel, you should be able to come off of mute now.
Yeah, it seems just with my experience working with helping people get on quite a few different services, the minimal supports really depends on each beneficiary. Some, all they're going to need is help with that financial piece, the federal employer identification number, the payroll, taxes. They'll be able to manage their own care. Besides that, they'll be able to supervise and know the quality of care, or maybe find a different family member if they're not receiving that quality of care, where others are going to need more assistance, such as CDWA or an agency would provide. So it seems like having the FEA model, where there's kind of 3 different tiers of support depending on each beneficiary, to provide them that more option and to really go with their own desires, could be a good model versus restricting beneficiaries who have the ability to do all of those things, maybe just need physical assistance, to the same as other beneficiaries who maybe cognitively need the higher assistance provided by something like CDWA or an agency.
Wonderful. Thank you so much. And thanks for coming off of mute and sharing your voice with us. Really appreciate that. I'm going to jump back in the chat here, but again, raise your hand if you'd like to come off mute or continue in the chat. I see here having beneficiary education that helps identify which options are best suited for family caregivers in varying circumstances. And beneficiaries will need to understand what services a relative caregiver can and cannot provide. Okay. Wonderful. So I'm going to move us to the next question, but it's going to be very similar to this one. So if you have some thoughts, feel free to still bring them up. I'm just going to expand this question out to what are the minimal supports needed for the family caregiver? So changing our lens here from beneficiary focused to the family caregiver. But again, if you still have some thoughts about the minimal supports need for the beneficiary, or as we talk about the family caregiver, it sparks ideas for the beneficiary, please continue to share that. There's no rule here that we can't kind of talk about multiple at once, but it just kind of hoping to spark some ideas as we go here. So jumping back in the chat here, I see support that help beneficiaries manage the caregiver, especially if they are family members and the beneficiary has had problems with this family member. Christine said, I would like to echo Ryan and Lynn's feedback. I appreciate that the FEA third option potentially improves access to care, especially for our rural caregivers. Training specific to beneficiaries' condition, and then our family caregivers under all models mandated reporters. If so, they need training to identify what abuse, including self-neglect, might look like. That's a great call out. And then could easily have a checklist for family caregivers that helps drive them to the appropriate option. All right. So what else? We have some really great ideas here. And just for those of you, as we're talking here, I'm one of many here within the room for WA Cares. And many folks here are going to be taking notes, and we'll also be reviewing this chat later. So no, while we're not necessarily diving into each comment here, we are collecting them, and we'll be using that to inform eligible relative care. So continue with these great ideas here in the chat. Hi, Maddie, I see your hand up. You should be able to come off mute now.
Hi, can you hear me okay?
Yes, I can.
Okay, great. My audio's been a little tricky today. I think definitely echo what I'm seeing in the chat around, training supports, emotional supports. One perspective I would bring from SEIU 775, the Union of Caregivers, is that they're often in care delivery models through like fiscal agents and others, seen it sort of in the past in Washington, but also in other states. There are challenges with caregivers getting paid on time, tax withholdings, that sort of thing. And so I would say support navigating any issues. Obviously we've expressed, our desire to have for family caregivers to have the right to unionize, because in our experience, having the union grievance process has allowed advocacy and support for, those payroll issues. But broadly, to answer this question, I think, support if taxes aren't withheld or you aren't paid on time or that sort of thing, that seems minimal from my perspective. Thank you.
Yeah, thank you, Maddie. Thanks again for coming from mute here and sharing with us. I think that's great to hear. I'm jumping back into the chat here. Starting up here, we have emotional support. Caregiving is such a hard job. Family caregivers need a smooth and quick process to get paid for the care they are already providing. Important to make sure that family caregivers know where to turn for resources, training, and additional support. Lynn's agreeing with Marguerite. It would be good to show options for the family caregiver as well, so they can decide. So they decide what would also meet their own needs. Let's see here, adding my agreement to Marguerite and Lynn's feedback. Okay, we have a number of folks agreeing with that. It'll be important to provide information to family caregivers if there's a need for long-term support and caregiving. In other words, what happens when WA Cares dollars are used up, and if they are or are not on Medicaid. And I see here, we also believe that caregivers need the ability to collectively bargain so that workers can deal with issues that may arise with a fiscal agent, such as inaccurate pay or tax reporting errors. And then looks like I see a potential to align WA Cares with the FCSP, which I believe is Family Caregiver Support Program. in terms of additional support for caregivers. And then also access to an easy path to understand and access the correct required training so they remain eligible to be paid. Unclear how caregivers would be notified of their training requirements and how to meet them under FEA, particularly at this point, either agency with choice or fiscal employer agent would be supported by the established training partnership, providing training to Medicaid caregivers. All right, wonderful. Really, I think we've gotten so much great feedback. Muriel, I see your hand up, and you should be able to unmute now. And this will be the last comment. We are going to move on to our next prompt here, but continue giving comments on this and ideas as they come. But Muriel, you should be able to unmute now.
I think this would be for the family caregiver being able to receive any paperwork and training in a variety of language and format access. I know I work with Aging and Adult Care of Central Washington, and we've got quite a few rural clients that technology is a struggle for, both for the beneficiary and for the caregiver, including ones who live outside of regular Wi-Fi or cell range, still rocking a landline. And so just for that minimal supports, if there's, with those training requirements and all of that, having options that really support our clients that maybe aren't tech savvy or don't have easy access to technology, as well as those language barriers.
Wonderful. Thank you for bringing that up and also calling to attention the technology gaps that exist out there. I think for many of us, it's easy to look past that, but I really appreciate bringing that back up and recognizing that we have people living all different kinds of experiences here in Washington State and different levels of access to technology. All right, I see a number of folks agreeing with that access, the accessible training and language access. So let's move on to our next prompt, but if you're typing, keep typing, that's okay. I'm going to, there we go. Our next discussion prompt here that I'd like to spend some time on with you all is thinking about the agency with choice model specifically. And we will have a question here regarding the fiscal employer agent as well. So please know we will be getting to that. But for today, I want us to talk about the question you see up on the screen, which is what should be considered for the agency with choice model. So we've talked about the agency with choice a bit. We have that handout here from earlier on that we put in to kind of help give you the visual that we shared through the slide deck. But thinking about the agency with choice model, what should be considered? I'm curious to hear from you all on this, specifically for that agency with choice. And again, we will get to fiscal employer agent. So if you're itching to go on that one, we'll move to that next. But let's stay focused on agency with choice and what should be considered. So I'll look for hands up or the chat. See what folks have to say. So it looks like Danielle put in the chat here, the existing pathways for paid family caregivers are already extensive, but the commission is committed to going forward with adding a third option. Agency with choice is a better model for ensuring quality care and protecting the rights of care workers. Looks like they don't, Fair Work Center does not support creating systems that strategic or that categorically deny workers the right to collectively bargain. Just like other exclusions. So thank you for that. And then Ruth's asking for a definition of that, of agency with choice. And I'm actually going to see if Christine can help me out with that, with a brief definition of agency with choice. And it may be helpful just to put it in the chat so folks can see it and refer back to it as we have our discussion. But Christine, I'll look to you to see if you can assist with that.
Yeah, so briefly, I'll put it in the chat as well, but an agency with choice. So again, that's the co-employer or joint employment model where the agency does all those administrative tasks, the hiring, the payroll, etc. But the beneficiary or the client does the day-to-day managing. So they're selecting the hours, the schedule, the tasks, and they're kind of overseeing that piece. So again, the agency with choice is that joint employer model. And I can put something in the chat. Did that help, Ruth? With so okay.
Well, thanks, Christine. All right, looking to you all. I know we've had some comments along the way about agency with choice in both directions. But just thinking about those considerations, feel free to share them again or in more detail. Really curious to hear from you all, particularly with this agency with choice, because that is something we're more familiar with here in Washington because of Consumer Direct, or CDWA, which is considered an agency with choice. All right, Maddie, I see your hand up. You should be able to come off mute now.
Yeah, I think something around streamlined hiring would be a good thing to consider around an agency with choice model. Like how to, from knowing you want to become a family caregiver to actually getting paid, like how are you able to streamline that and make sure that deadlines and everything is articulated very quickly?
Wonderful, thank you. All right. I see Lynn added in the chat ability to manage volume and assist beneficiaries and caregivers with the onboarding process, ease of process for both beneficiary and the family caregiver. With CDWA, I've had both beneficiaries and caregivers be confused on who the caregiver's employer actually is. I'm concerned that this would be the same for another agency with choice. Christine dropped the definition here of agency with choice in the chat. So for those of you who want to revisit that or see it to help process, Christine dropped it in the chat, and Christine said agency with choice is the joint employer model where the agency will provide the administrative tasks and the beneficiary would be the managing employer. Ruth said great record keeping if there is a dispute between family caregiver and beneficiary. And Stephen said a great deal of informal care is provided in tandem with formal care. Since WAC Cares doesn't include case management and not much care coordination, might the agency with choice model be better at helping a beneficiary execute their plan of care? And I'm curious what folks would think about that. I think that's a great question for folks. If you're interested in engaging with that, I'd be curious to hear your thoughts. About whether agency with choice may be better at helping a beneficiary execute their plan of care. So curious what folks have to say about that. And also our question here just about those general considerations, what should be considered for the agency with choice model. So we'll give it another few, maybe another minute or two here on this question. Looks like a lot of folks are still digesting, but again, we also have that question here in the chat. About the agency with choice model and whether it would be better at helping a beneficiary execute their plan of care. I'm curious what folks think about that. Mike said that there'd be some unnecessary bureaucracy. Mike, I would be curious if you could expand on that here in the chat a little bit more, or you're welcome to raise your hand as well. But just to drill into that a little bit to know what when you think about that unnecessary bureaucracy with agency with choice, what is it that comes to mind, just so we can be clear as we look at these notes later. All right, well, I'm not seeing a lot of activity here right now on this question, so we'll move along. And just again, if you're thinking about that agency with choice, keep thinking about it. That's okay. You can add that into the chat at any point or raise your hand and come off mute. But I am going to let you start thinking about this question, which is what should be considered for the fiscal employer agent model. So now we're going to be focusing in on just that fiscal employer agent model. And then also, we do have some outstanding things in the chat here just around whether or not the agency with choice model may be better at helping a beneficiary execute their plan of care. And then I also have a question out to Mike around that unnecessary bureaucracy, if we can get a little deeper so we can understand what that represents. So I'll pause here and let you all digest a little bit. But again, the question is, what should be considered for the fiscal employer agent model? All right, Ryan, you should be able to come off mute now.
Thanks. I think we need to consider the volume of beneficiaries that is going to be coming through this process. The volume of beneficiaries for CDWA was something much larger than anything they had handled in any other state, and we saw how that overwhelmed them and ground the system to a halt. So I think with the number of beneficiaries coming in, if there is any ability to streamline a process and really to create a different option. It's interesting to me that we're considering as a third option another CDE. That seems like a repeat already available option, more so than something new and different. So I think with this, I think family caregivers, if they're able to get through the process more quickly, they know what they want. The beneficiary knows what they want. This really creates a third option, but those who want to go the CDE routes still could choose to do so, or the home care agency route. So I see this not so much as an either or, but could this be a both and?
Yeah, that's a great call out here of thinking about the options we currently have and what we're trying to create. So thanks for calling that out. The other thing that really resonated with me in your comment here is the volume, and recognizing we have a lot of family caregivers out there providing care, who will be providing care, and thinking about how to manage that volume either with agency with choice or fiscal employer agent or both. So thanks for jumping in there. All right, I'm going to check in the chat real quick, and then I'm going to jump back to the hands. I see we have a few hands up. Maddie said similar comments, streamlined hiring, support with training and other employment requirements. One concern with the fiscal employer agent for us is lack of clarity about who has certain responsibility and impact on right to organize. We don't support creating systems that categorically deny workers the right to collectively bargain, just like we don't support other exclusions that deny workers minimum wage just because of the kind of work they do. We're also concerned that the fiscal employer agent model is less clear about who would be responsible for ensuring things like caregiver eligibility, training, and background checks. All right, let's see here. And I do see here that some of the chat that I'm reading out is not going to everyone, and I didn't catch that. So if you can, please write in the chat to everyone, just so everybody can engage and see the comments that are being shared. And if you're not comfortable, I understand that, but I think it can be helpful for folks who are following along for it with us. All right, I'm going to turn it over to Peter. And you should be able to come off mute. I do want to be aware of our time here, so I'm just going to ask folks to be just conscious of their time, and then I'm probably going to move us along to our next question here shortly. So keep going in the chat, but for now, I'm going to turn it over to Peter.
Thanks. I'll keep it real brief. The comment about overwhelming the system made me think, when the actuarials looked at the cost of this, did they consider the third option when they looked at the cost? Or were they just basing it on the two current models?
Right, and I see, I think maybe we have some answers here. I'll pause, Ben, if you want to jump in.
Good question. I am not aware, and I've been deeply involved in the process with the actuaries. I don't recall that being a topic of discussion with them, that they've modeled it, taken that into consideration one way or another. Unless you can correct me on that, Andrea.
I think you're right, Ben.
Maybe you could say a little bit more about what the implication would be of one model versus the other for the modeling.
Well, just in a real blunt way, the system right now, the long-term care system, I'm talking private system, is really not geared towards paying family members. And if suddenly you threw that out as an option, I think that would have more people taking that option out to say, yeah, I'll get paid for taking care of my loved one, as opposed to I'm going to let someone else come into my house. So I'm just wondering if that has been modeled anywhere, thought of as far as costs.
Interesting. Well, I know that the actuaries are very well aware that family caregivers can get paid, so they have taken that into account. And you're right, there's a certain potential, I guess they call it a woodwork effect, but they are aware of the program design parameters and that family members can get paid. So I'm confident that's been taken into consideration. But of course, all of this is new, and we'll have to wait and see what our actual experience is to see what take-up rates are and so forth. Um, so.
All right, wonderful. Thank you both. I am going to turn it over to Muriel now. Muriel, you should be able to come off mute.
Thank you. Yeah, one of the things just for the Fisker employer agent model, I know people have brought up talking about benefits for caregivers and for family. And just from my experience working with people, there are, for an FEA model, they're not looking at this as like a long-term career option, caring for their family member. Maybe this is a family member who's got a terminal illness or other, it's more of a temporary thing. And so having the streamlined process, like they're not looking to get benefits or the other things, and they're not looking, that this is going to be their career for the next 5 years, caring for their parent or whoever it is. So having that kind of streamlined model, just so that way they can get paid and be able to help take care of things in the moment or for the next, 6, 8, 9 months, versus like a long-term caregiving deal.
Wonderful. Thank you, Muriel. And that's a great call out to, who our audience is when thinking about family caregivers, recognizing some of them may be more short-term in meeting their family members' needs. All right, Ryan, I'm going to give you permission to come off mute here. You should be good to go.
Thanks. That just got me thinking, this really is a short-term intervention that if the fund, that 36.5 was really designed around the average cost of in-home care in a year. So I think it behooves us to want to streamline the process because it's not going to be a long-held role through this funding source. And so while using this funding source, there should be an option to make it as easy as possible.
Wonderful. Thank you. All right. Well, I am going to put our next question up here on the screen, just being aware of our time. I will jump back into the chat here in just a second, but our question is going to be, what should be program requirements for either model? So it's going to open it up to both Agency with Choice and the Fiscal Employer Agent. But what should be program requirements for either model? And as a reminder, we're here today regarding rulemaking, so really thinking about requirements, rules, those types of things, but really also trying to understand this model. And that's where a lot of our questions have been coming from of what are we picturing? But looking to you all, I think we've already kind of started this along the way in our discussion today. Let's dig into what should be program requirements with either model. So while you're thinking about that, I'm going to jump into the chat and read some of the comments that have been coming through while we've been talking here, and this is going to be about our last question. Looks like using a payroll service would significantly simplify the hiring and payment process for caregivers and the sheer volume, ensure that all financial and legal obligations are met. Payroll services for family caregivers currently exist and should be leveraged in a direct payment option. Once the caregiver caregiver beneficiary relationship is defined as an employer-employee relationship, it would help to mediate concerns regarding quality of care. And I think that is a pretty big question for us right now. Is like, what does that look like? And so I'm curious if folks have thoughts to that. This is regarding Christoph's comment here earlier in the chat about who would help to mediate concerns regarding quality of care. That caregiver beneficiary relationship once it is employer-employee relationship. Let's see here. Coming on down here. There was some reference earlier in the presentation to a limited liability of the FEA option. What is the result of that? I'm not sure if anybody here, if Christine or others may know more about that. But if not, we may need to follow up with you, Maddie, I personally do not have the answer on that one. So I see Christine came off mute. I'll pause here.
Yeah, just looking at the question. So reference and persistent to limited liability. I think that might have been in reference to, a fiscal employer agent not being the legal employer. Therefore, they are removed from certain liabilities around the employer. Then in an agency with choice model might be where they're the legal employer and they have more responsibility and liability around having the employees. That's probably the best I could answer, maybe, if that's helpful. Yeah.
I muted myself. Thanks, Christine. B added in the chat, I've heard an interest in having a requirement around a grievance complaint resolution process. So we're definitely hearing that both in the first one and first session we've had and the second session regarding eligible relative care. Maddie added regarding the fiscal employer agent, if there's not health insurance offered, there should be research and an understanding of adverse selection impact on health benefits for existing caregivers, ensure there's not unintended consequences. And then Muriel added, the more requirements there are, the more barriers there are for family members to be paid and for beneficiaries to access benefits, as well as the more time between when the care needs arise and benefits can actually be received. Christoph added, definitely interested in a grievance complaint resolution process, especially if there are issues with the financial agent. Wonderful. Kathy added, family caregivers should receive direct payment if they do not need or qualify for additional employment benefits from CDWA or in-home care agencies. For instance, the 2020 caregiving in the US study found that 87% of family caregivers report having health insurance primarily through employer-sponsored coverage or Medicare. All right, so let's think about this question here up on the screen. What should be program requirements with either model? We do have a little bit more to get through, so I'm going to keep us moving just a little bit on this. What should be program requirements with either model? So here, grievance or complaint resolution process. I see agreement for that as well. Ruth added, would caregivers be eligible for workman's comp in case of an accident in the home or injury while caring for beneficiary?
So I can jump in and just offer a reminder that yes, under agency with choice, those taxes and workers' compensation would be required to be withheld, and it's something that we could build into the FEA model as a program requirement, but it's not required on the outset of an FEA.
Wonderful. Thanks, Christine. Kathy, I see your hand up. You should be able to unmute now. And Kathy, if you're talking, you are still on mute. All right, Kathy, you should be able to come off of mute now. All right, well, maybe we're having a little bit of technical challenges there. Kathy, you should be able to come off of mute still. Feel free to jump in here if you're able to. I'm going to jump back into the chat here for a second. And Mike said most family caregivers wanting to provide caregiving services are doing it on a short-term basis and want a simple, easy pathway to get paid. They don't want a long and extensive process. Think tons of paperwork, issues with technology, getting supervisory approval, and so on. Thanks for adding that detail for us, Mike. That's really helpful. And Maddie added, I think L&I should be a requirement of either. All right, and I see here, agree with Maddie's comment. Many family caregivers are older and are disabled themselves and at risk of injury due to the physical nature of work. Wonderful. All right, I'm going to look back to Kathy here. Kathy, are you able to unmute? Then I'm going to jump over to Marguerite, who also has a hand up. You should be able to unmute now, Marguerite.
Hi, I was reminded in a conversation recently that caregivers are not, we're not just talking about older caregivers, and that that caregiving is not just with older folks. So I think it's really important to understand that we are talking about a population of caregivers and beneficiaries who really range in terms of age and condition. And data show us that 61% of caregivers are employed while caregiving, and the majority of those are actually employed for 30 hours or more. So there's a lot of question around how much time and effort, and I think that's why having an FEA model and an agency with choice, CDWA, the home care agencies, I really appreciate the department looking at the wide range of options that meet sort of really the many differences in situations that caregivers are coming from.
Wonderful. Thanks for sharing, Marguerite. I think, yeah, we have so many great options available to us out here, and I really appreciate our opportunity here to digest all these different options, think about what that could look like. So thank you. All right. I see we have a number of things going on the chat here. I am going to move us along to our next slide, which is our last question of the day. If you have some thoughts about any of the ones we've covered so far, keep going in the chat. Feel free to raise your hand. All that's fine, but I just want to make sure we get through our last question. And our last question for you today is, what factors should we be aware of when balancing supports offered through eligible relative care with the cost to the beneficiary? And so, as we discussed earlier today, there are some differences between these options and may have a little bit different cost to the beneficiary. So what factors should we be aware of when balancing supports offered through eligible relative care with the cost to the beneficiary? All right. And I see a question earlier from Uriel. Is citizenship of either the beneficiary or a caregiver a requirement? And it is not a requirement for the beneficiary, but there is a requirement for the caregiver. I believe, I'm pausing now, that yes, they need to be eligible to work in the United States. So, all right. Lynn, I see your hand up. You should be able to come off mute.
All right. Yeah, when I look at this one, I think it's that balance is so true of trying to figure out, and that's where I really appreciate just the wide range of options that are being proposed, because we're making sure people have that choice. So if they don't need additional health insurance and other coverage, or maybe they're not going to be working enough hours for a family member that they would qualify for those benefits anyways, having a FEA model really, really does help make a difference so people can use the benefit and make it go a little bit farther. And yeah, it's just kind of really feels like having multiple options really helps people balance and kind of think through, as the beneficiary, which of these models work for me? And in cases where maybe the beneficiary has some difficulties choosing, or other, maybe there's conflict between what they want and what their family member wants. It's a joint agreement around what pieces to come together. So in some cases, it may make more sense for people to choose CDY if they think they're going to continue on into Medicaid. They know it's a long-term need and it's going to continue well past their benefit. That's where I really feel like having that good counseling for people to really give them the support and tools to make informed choices is really, really important. And I definitely do appreciate just all the thought that's gone into creating additional options. Thank you.
Wonderful. Thank you, Lynn. Thanks for jumping in there. I am, let's see here. There we go. Ruth, you should be able to come off mute now.
Hi, thank you. So I worked as a family caregiver specialist during my career, and I'm a little jaded because I saw a lot of family caregivers not really providing the care. These were unpaid and paid caregivers, but they were not always providing the correct care, or they would be out. Like if a child was caring for her dad, but the mom was still alive and the child was there because the mom couldn't do it all, but then the child would leave and the mom would still be responsible for the husband. I just seen a lot of abuse of the system with family caregivers. And so I hate to sound so jaded, but I totally support family caregivers being able to have this option, the third option. I agree with that, but we have to have some sort of systems in place to make sure that abuse does not happen. And the care receiver or the beneficiary is afraid to tell somebody. And if there's no care managers, who are they going to tell? I just think we should think about that very carefully when we're offering this third option, so that the beneficiary is protected, or even the caregiver is protected if the beneficiary could be abusive to the daughter or the son. I've seen both of those things happening. So that's my point.
Wonderful. Thanks so much for sharing that, Ruth. And I think that is absolutely a great call out of that protection piece. I know we're running low on time here, but I would be curious if you have any ideas on how to address that through either of these models. I'd love to hear it in the chat. I'm going to turn it over to Kathy here, who has a hand raised. And Kathy, you should be able to come off mute now.
Hi. So I appreciate all the work that the agency has done on this and this very thoughtful examination of a very important issue. And I wanted just to comment on several things I've seen in the chat. Family caregivers are already doing this work. They do it day in and day out, and are rarely compensated, putting themselves, their own financial health at risk. This is a short-term benefit. This is in order to help somebody when they are in a time of crisis, when they find that they have to take off time from work in order to care for mom or dad or a sister or brother that has had a terrible accident. So I think it's just really important when we're balancing, and I really struck on this balance of supports, that this is not Medicaid. This is not the state Medicaid program. This is a limited benefit that families can access in order to help them move from moving further into crisis. And, there is abuse and neglect in all situations. CDWA is not immune from it. There are challenges and issues throughout the whole entire system. There is challenges within family dynamics that will still exist with or without WA Cares. But I think it's important to continue to keep in mind that oftentimes a lot of the care planning is not necessarily by a third-party entity. It's between a family to decide how that care plan is and to work with the primary care physician who makes a determination about pharmacological interventions, or they make decisions about, this person is a danger to themselves and others and needs 24-hour care. And at that time, the family can make a decision and the beneficiary can make a decision. But I feel like we continue to apply a lot of Medicaid standards and a lot of Medicaid history to a program that's new and innovative. And I really want to continue to look for ways to challenge ourselves to think outside those boxes. And again, create an opportunity and program to support those family caregivers that are going to be coming into this system, realizing and recognizing the terrific financial, emotional, and physical challenges that it takes on a person to be a family caregiver.
Wonderful. Thank you so much, Kathy. Thanks for closing us out here. We are at the end of time, and so I'm speeding us along here. We have the DSHS rulemaking website in the chat along with our partner agencies. You'll also find my email address there. So if you have some questions or comments after we close here today, you know where to reach out to. Please send those over to me, and we will add that to whichever topic we're here to talk about regarding rulemaking. We do have an email address for the WA Cares program. If you have questions about WA Cares, you're welcome to reach out to that wacares@dshs.wa.gov. Otherwise, thank you so much for being here, for participating. Your voice is just so wonderful as we digest all of this really complicated material. I think today we heard a lot of great information that helps inform us on, how to move forward with eligible relative care. So once again, I really appreciate y'all for being here. And please make sure you are signed up for rulemaking notifications so you know about any future listening sessions about eligible relative care or any other rulemaking that we're going to be doing with WA Cares. So thank you all again for being here. I appreciate it, and have a wonderful rest of your day.